Have you ever read something that said, what the heck does that mean? If you're an aspiring law student or a current law student, I'm sure you've encountered some words in the legal opinions you've read or in legal documents, and you don't even know how to pronounce it, don't know what it means, and don't know how to use it. So in this video, I'm going to talk about 10 legal words that you'll probably encounter in your career, what they mean, and how to pronounce them. All right, let's talk about it. Okay, the first word is notwithstanding. Notwithstanding. So a lot of times you'll see this word in contract provisions. That's the various contract provisions, right? So what it basically means is it's basically a triple compound word, right? Notwithstanding. Whatever was said prior to whatever this paragraph is, meaning aside from all that was said, whatever is about to be said in this particular paragraph, that's the prevailing thought, right? So notwithstanding everything I just said, whatever I just said, basically, if anything is in contradiction to any of that, the paragraph that says notwithstanding shows you this is what the prevailing information is. So I know sometimes contracts will be very lengthy. They can say a lot of different things. Some of the terms can appear to be contradictory. The notwithstanding paragraph is lawyers' way of saying, we're going to cover ourselves so that if anything doesn't make sense, this is what we really mean by it. Granted, you could also make it more clear and not need a notwithstanding paragraph, but if you do see that in your legal jargon or readings, that's what it means. Okay, the next word is veracity. Veracity. So you'll see this word come up a lot in the context of witnesses or somebody who they're evaluating their credibility, right? It comes up to veracity basically means the character trait of telling the truth, right? So the veracity of the opinion, the truthfulness of an opinion that a witness said or that someone made a statement, whether it's true or not. You'll see it a lot of times in, let's say, court opinions when the judge is assessing whether he or she thinks a witness or evidence is true or not. So veracity. This is a popular one, hearsay. Hearsay is something that even non-lawyers use, but I think use incorrectly. And hearsay is when you want to admit an out-of-court statement in court to prove the truth of the matter asserted, right? So there are a lot of things that hearsay is not. Hearsay, I'll give you an example. So let's say you want to introduce a statement that somebody said to prove that they're lying, right? You can't introduce a statement that the person said out of court, in court, to prove the truth of what they're saying. So you can't say, Barbara said that she was going to go to the store. When you were introducing that statement in court, you can't introduce it to prove that Barbara was actually going to the store. Now, you can actually use it you can introduce that statement to prove Barbara's state of mind. You can prove a motive for something. There are other reasons why you can introduce an out-of-court statement in court, but it can't be used to prove the truth of the matter asserted, right? So hearsay is a popular one that, like I said, non-lawyers and lawyers use alike. Comment below other terms that you may have encountered that you're like, what does that mean and how did I use that in my work? Also, make sure you hit the thumbs up button. It pushes it out to the YouTube algorithm so that other aspiring lawyers, other law students who may not know about this information can be received in their YouTube feed. The next word is moot, right? And I think this is another word that maybe some lawyers and non-lawyers use alike, moot. So if something is moot, it is no longer of issue. It's no longer anything to argue about. A lot of times a court may say certain issues may become moot because they may have gotten resolved by something else. The parties may have dropped the issue and no longer are contesting certain things. So when something is moot, it means it's no longer needed to be discussed because it's been resolved one way or another. Moot. For those of you who watch my other video that talks about how you kind of read case briefings and things of that nature, you might have seen the phrase set aside. The court has set aside the lower court's finding, things of that nature, right? So set aside is used, like I said, in the context of deciding whether a previous decision made by another court, usually a lower court, is no longer valid. So let's say a lower court denied something or found somebody not guilty or guilty. A higher court can set aside that judgment and say, no, this is the new way we were deciding on this particular issue. So setting aside is essentially what it sounds like, right? We find certain information and we're going to put it to the side because we no longer think that's the correct law. Here's a popular one for a lot of 1Ls, and you might see it if you're an aspiring lawyer. It's called the clean hand or unclean hand theory, right? So what it basically says that when a plaintiff or somebody is coming to court to allege that somebody did something wrong, defendant's argument can be that the plaintiff has unclean hands, meaning they had some kind of responsibility in the matter and that the defendant is not solely responsible for something. So the unclean hands doctrine. And you want to say you have clean hands. You want to say that, nope, this is nothing of my fault. A lot of times it comes up in contributory negligence to say like, well, if I'm wrong, they were a little bit wrong too. So therefore I shouldn't be 100% responsible for something. So it's called unclean hands. And that's, like I said, you'll see it a lot in a lot of the tort cases when you start 1L year of law school. Here's something that you may not know, the word utter. It's used in the context of when you try to pass a forged check, right? So utter a forgery. Something that you are not permitted to actually have access to a person's accounts or information, and you try to pass a bad check, right? It's called utter. So utter a forgery is something a lot of times used in kind of maybe business organizations. It can also be used in criminal senses as well, but the word utter. Okay, the next two kind of go together. So it's de facto and de jure, right? One is to say that it's not established in the law, but it happens in practice. And one is de jure is talking about things that are in law, right? So de jure segregation. You may see that in the civil rights cases where there were actually laws in the books that said that their segregation was legal. Then you have de facto segregation where it's like, okay, now that we've said that certain segregation things are illegal, but in practice, people still actually carry on with these segregation practices, right? So de facto, de jure. In fact, what really is happening, de facto, de jure, by law, this is what happened. So both of those, you'll see those a lot, like I said, in civil rights cases. Okay, the next one is for our criminal justice or future criminal defense lawyers or prosecutors. It's an indictment. And an indictment is a charging document that is usually handed down after an investigation happens. The investigators, the police officers go before a grand jury, which is a combination of civilians such as yourself who decide whether there was enough information to find a person, usually has to be a felony, guilty of a crime, or is enough information to say that they perhaps did the crime. It's a charging document, an indictment, right? So without an indictment, usually you can't move forward to charge a person. And that's, like I said, a charging document that starts basically the criminal felony process. I think this is number 10, but if not, I'll go back and check. So the 10th word is memoranda or memorandum, right? And you'll see it a lot, perhaps as an aspiring law student, definitely as a law student, where you're required to write a memorandum. A memorandum is a document that has issues that are perhaps being debated. You list the issues and then you decide based on your research what the conclusion should be on it. And usually you're writing it to, let's say, your professor, or if you're in a fictitious world, to a partner, someone in authority to you, based off a question they asked you something. So let's say, whether it's okay or whether it's legal to do these things. Your job is to go find out the answer to that question and reduce the information into a concise written document. So it's a memorandum or memoranda that you produce to someone else to explain information. You could also be writing it to a client to explain some information that you did research or something. Will I be found guilty? This is the reasons why you perhaps would be. These are the reasons why you wouldn't be. It's, like I said, reduced information based on research that you have conducted. Hopefully, I brought some context to some of these words that you've seen and you don't go, what the heck does this mean anymore? Comment below if you have, like I said, any other comments about words that you've seen and you're like, what the heck does that mean? Even if you Google it, you're like, I don't know how to use it in context. Like I said, in the legal world, there are a lot of legal jargon, legalese. Sometimes it's not necessary. Sometimes using a $2 word will suffice. You don't need to have such, elaborate language to explain certain things, but sometimes it's been used so long that people just assume that you know what it means. Hopefully you found this video helpful. Like I said, hit the thumbs up button so that it pushes out to the YouTube algorithm, and we'll see you next week in a new video.